And refresh. Yeah, we're live. We're live. Yeah, right. So, hi everyone. This is Joseph, and this is Margaret.
Hello.
We're gonna try to have Margaret join me as much as possible now. It's just so lonely up here.
And this is Margaret.
Mute it. Well, just
Okay.
mute it. Right. Okay. Yeah.
Okay.
And it's a little bit lonely up here, and I mean, it's nice to have her here. She'll be able to read the question. She's also a manager here. She's been here, I don't know, probably 10 years now. I like to tell people that because in fact, we start counting from the moment you were an intern, and then you for it all the way up to now. Margaret does really, really good work, and I just want the opportunity for the world to get to know her a little bit more. Right?
Thank you. Yes.
Today we're going to talk about the main news really is global entry not being able to be used because of the government shutdown. This might be short-lived. Maybe only some terminals won't allow global entry, but this is a big deal for green card holders who are overseas or for people who have global entry and they don't have a green card and they're entering the country. Why? Because of the chaos that we're seeing at customs, whether it's at the land border or it's at the airport. And while researching this story, talking about global entry, re-entering, and just, what is it like to enter the country without a global entry? I mean, I don't know how long it's been since I entered the country without a global entry, right? We've had global entry since it was it first came out. And we recommend a lot of our clients get it, and a lot of clients who have difficult cases, having global entry is just a little bit extra protection. And now people are freaking out because people need to enter now, and there's a government shutdown, and it was announced that global entry cannot be used. And while researching this particular story, we found out there was this UK tourist who got detained for 6 weeks at the border. That is at the Canadian border at that. And that was just completely bizarre, right? Like, a couple weeks ago when we were talking about this, I talked about the 72-year-old grandmother who came in as a green card holder who got detained. We talked about other Europeans who came in as green card holders who got inspected, even though they were only out for like 3 months to 6 months. Now it's a UK tourist with a valid visa getting detained by ICE for 6 weeks. That was relatively recent. Looking into it, trying to fact check, trying to double check exactly what's going on. Now, from everything I know, from what I was reading the story, it's not as simple as that. She was, being accompanied by another individual who, they had more questions about, so they thought he was an accomplice. But the pure fact of the matter is that she was from the United Kingdom. She had a tourist visa. It was valid. She was trying to, leave the country, not even enter the U.S. She was trying to leave the country, but because of customs determination, she was sent over to ICE, and now everything got canceled. And she just directly went on The Guardian to say, please do not come to the U.S. If I could get detained, anybody could get detained. And rightly or wrongly, that is what's going on. And with that being said, there is such a fear of people entering the country with valid visas, with valid green cards. Because just because you have a valid visa, just because you have a valid green card, doesn't mean it's going to be a free pass, simple entry. Different people have different problems. And when you used to have global entry as a shield, potentially you get through a little bit easier. But right now, because of the government shutdown, because Congress did not authorize additional funding, because the Department of Homeland Security does not have the funding, they have to shut down different programs. And they said TSA and Department of Homeland Security global entry is now canceled. Now, we talked with CBP officers. We know at least the LAX ones have not been canceled. And even if it is, there's the private service route, which is effectively global entry, and that is not canceled as of yet. And so we are concerned. And we just want to let people know that this is what's going on. Why does having global entry protect you a little bit? Well, because global entry essentially serves as a barrier to show that you've already been background checked, right? A lot of my clients, and they're always asking us, what is the motivation of customs officers? What do they want? Let's give them what they want. And my response is, I know your issue, and I know that's all you think about. Maybe, because your green card is expired. Maybe because you left the country for over 1 year, 2 years, 3 years. Maybe because you've been warned in the past, and you think that that's all they care about. That is not. That's in your situation, but to them, it is just a job. They are a government worker. They don't want to have trouble. They don't want to have hassle. They want things as simple, as clear as possible. And they are much more concerned about drugs and gangs and national security. A green card holder leaving the country for, this amount of period versus that amount of period is not the top of the thing that they care about. You should still need to answer appropriately. You shouldn't lie. But having a global entry at least removes you from the potential to be a national security threat, a criminal, because you got one layer of protection. And that's why, giving a global entry is not a replacement for a reentry permit, right? Because having a reentry permit is what allows you to be out for so long. But global entry at least makes you so that you're not an FBI threat. Usually by now, Galen would be asking me all sorts of questions. So just checking if there's any.
So we have two questions, more so related to family.
Okay.
Do you want to jump in?
Go for it. Go for it. Yeah, I'm at a stopping point for the success, the news. So feel free to ask me questions.
Okay. So the first one is, how long is it taking VAWA to approve after they received RFE and fingerprints?
Oh. So fingerprint doesn't mean anything, right? Fingerprint is just part of that process. You file it within a month to 3 months, you get the fingerprint, and the case keeps on going. It is not a pre-adjudication. It does not mean your case is going to be approved or denied. Don't read into it. It's just part of the process. At least they accepted the case, right? So that's the thing. Now, if you got an interview or you got a request for evidence and you responded to it, it's going back to that same officer who's adjudicating your case. And usually they're incentivized to want to approve it or deny it within a month. That's the goal. If there's extra complications, they have to order a fraud inspection. That's a different story. But in general, all applications, not just VAWA, if you got to the request for evidence, if you got to the response, I would say between 1 month to 3 months, you should have a final notice. With that being said, have we seen double requests for evidence? We do. It's rare. Do we see a double interview? Also, we have seen that. Do we see requests for evidence and then interview and then potentially another request for evidence? Also happens. But that's the main idea. If you responded, it's back on their desk, it's on their plate, they have to do it. One thing that I think a lot of people don't know is in the past, when officers adjudicate a case, every action they take, they get a point. So they answer a request for evidence, they get a point. They issue a request for evidence, they get a point. They do an interview, they get a point. Every action, it's like, oh, you're productive, you have a KPI. However, nowadays, it's only approve or denial. You only get a point for that. Yeah. Everything else in between, sorry, that's just you doing your job. But you only get points for moving people along through the final process. And so the point of me saying that is they don't find joy in giving requests for evidence. Actually, it's causing them more work.
Yeah, I think like you said, it's a good sign if you got an RFE, because at least it means that they're actively reviewing it. But it kind of depends on when you got the RFE, because overall it could take about 3 to 4 years. But if they issued the RFE fairly early, it kind of gives them more time to spend on the RFE response versus if you're already closer to like the 3 or 4 year mark. Then, like Joseph said, it could maybe take like a month or two, but it really just depends on like the overall timing of everything.
Yeah.
Okay, so the next question is, can my wife apply for a tourist visa for Madrid to see me in the U.S. while I-130 is pending?
Is Madrid part of the ban right now?
No, Spain.
Oh, got it. Makes sense. Need to improve my geography. Sorry about that. Okay. The answer is yes, you can apply. You might be denied. Even if you get approved, CBP might deny you, meaning the customs. Let me explain the argument that we use so you can use it for yourself. I-130 is pending, right? You're petitioning your wife. Obviously, you have the immigrant intent for her to join you, right? That's obvious. Now, when she applies for a tourist visa, the consular officer will see that. So would the customs officer. So how do you say I am going to be a tourist. I don't have immigrant intent, while there's something blatant that is an immigrant application for you. And the argument you make is, this trip that I want to go on, I do not have immigrant intent. I might have immigrant intent a year from now, 2 years from now, 3 years from now, from the big picture. Who doesn't want to go to the US, right? But right now, it is my nephew's graduation. It is my uncle's funeral. It is for this particular purpose. I will not overstay. I'm just gonna go do that non-immigrant tourist thing, and then I'll be back. And I will for sure come back because look, my family's here, all these things are here. I'm not gonna quit my job. It's still gonna take time to transition. Even if I do get the I-130 approved, there's still gonna be NVC and consulate processing. It's so long. I have to keep on working, right? I am, the executive producer for, Netflix here, and I have this big project that I'm working on. I cannot just leave and go to the US and transfer over, right? I have an important job here. That is the argument. It has worked many times. I wish it could have worked for you. Let us know.
Okay, so let's see. Next question is, can an F1 who has gotten his EAD via marriage, AOS, work off campus without violating his F1 status?
You are an international student, you got married, you filed for adjustment of status, you filed the 765, you got the work permit, and can you use that work permit to work off campus without violating your international student status? You know the answer.
I was like, no, that's kind of complicated.
No?
No.
Okay. The answer is yes, and here's why. Technically, and a lot of people have done this, the moment you file your adjustment of status, you already stop being a student. Like you can just stop going to school. Now that's not safe. That's not what we recommend our clients. We always recommend stay as a student. Do not cancel your student or violate your student status, because what if something terrible goes wrong with your 45? You could fall back on your student status, and then you could file a new 45, right? If you stop being a student, then you file 45, and then 45 gets denied, and you have nothing to back up on, then you get NTA, you could be deported. But if you have a student status, you won't get the NTA, so you can file 45 again, right? Especially in this administration, so it's super important. But if you already filed for adjustment status and you already got your work permit, technically, you don't really need the F1. That's only like a backup. You could just stay, and then you go to the interview, and the case gets approved, and you get your green card. So it's just a matter of safety. So with that being said, you got your work permit. You can work based off of that work permit. And just be super clear, you are working based off of the work permit that's available to you as somebody who's doing adjustment status, and not as an international student.
And Mark, can you check your Slack for me? We have some questions from YouTube and Instagram.
Okay.
Just if someone says handsome king.
Thank you. Thank you so much. Thank you so much. Compliment her too.
I was like, Margaret, you might get some people saying pretty.
Yeah, I know.
Okay, so it says, preparing VAWA as a man, my wife has accused me of things, and one of them is sexual assault. She used it to intimidate me, but I'm not sure if I should include it. Will USCIS question my character?
You are applying for VAWA. The U.S. citizen spouse, your wife.
Used like threats, basically,
Threats.
to intimidate.
To intimidate you to not file VAWA, or to somehow want you to be
deported,
right?
Well, I guess she accused him of sexual assault.
As well.
To intimidate.
Right.
Yeah.
So it's back and forth, right? So the answer is, well, if your question is, will this affect my case? The answer is yes, it will. Will it affect it for the better or for the worse? Depends on the officer, depends on how you prepare the case. Here's something for you to think about. If it's a real marriage and there is real conflict and there's real abuse, it's almost impossible that it's one way, right? Think about that. It's nearly impossible for it to be just purely one way, where there's the abuser and there's the victim. I mean, unless you're Epstein, right? But if you're not in that world, right, almost every other real relationship, any conflict, there's going to be truth on both sides. And so use that to show that this reality happened. This marriage, this conflict, this abuse happened. But you are not a depraved human being. What she said is not true. This is what happened. You have to make a case for yourself. So you shouldn't, so here's what I recommend you not do. You shouldn't back off completely and say, okay, I'm just gonna kowtow to this threat and I'm gonna withdraw my application and I'm just gonna listen and be subservient and suffer abuse. That's terrible, right? That's not a way to live. I also don't want you to be super confident that because of this, your case is still going to get approved. It depends on the officer, how they read it, right? So you still want to prove your innocence and prove your good moral character. You are not the type of person to do that thing. And do your best, right? So, yeah, that's my encouragement.
Okay, and then another question is in March, USCIS Visa Bulletin EB2 priority date is current, instead of usual 1.5 years of wait. As a Pakistani dentist, inside not clear yet, do I qualify for EB2 NIW?
Right, so if it's current, you can file EB2 NIW and 45 simultaneously. And while they're adjudicating your I-140, your 45 will just be pending. And here's the good news. Even if the priority date retrogress in the future, a couple months from now, let's say, that you already filed the 45 and you already filed the I-140, so you're lawfully able to stay in the US. So let's say, hypothetically, you filed the EB2 NIW, you filed the 45, and it takes 2, 3, 4, 5, 6, 7, 8 months if you don't do premium processing and to approve your case. And during that time, it retrogresses and suddenly you still have to wait for a year. You don't have to leave. You can continue to stay until it becomes current again and you go to an interview and get a green card. So that's the benefit of prior dates being current. And so you have your one shot, one opportunity this month, file it, right? Or next month, but you have to kind of prepare your case well and hope it doesn't retrogress immediately. Now, do you qualify for EB2 NIW? That's the $1 million question, right? With ChatGPT, with Gemini, with all these AI apps, I would recommend take your resume, put it up there and say, how would Zahn Associates Joseph argue your case for you? And do I have a chance, right? And then take a look at it, right? Or, get a couple opinions. There's plenty of doctors in different professions who have qualified for EB2 NIW, but it depends on your specific situation.
Okay, and then the same person had a follow-up question.
Yeah.
So do you think that this current priority date for EB2 seems permanent, or is it expected to regress back to years of wait?
Nothing is ever permanent in the world of immigration, sad to say, right? So we've seen this change flop back and forth. I mean, if you want to play with it, just throw that into Gemini, right? And say, hey, show me the priority date schedule over the years and how it flip-flops. You'll get these wild swings, right? It's absolutely nuts. So if it's open, be grateful that it's open. Now, trajectory-wise, in the next year, we believe that EB1 and EB2 will become more and more so available. But is there going to be a month or 2 months that's going to be completely change and fall back? How long is it going to stay that way? Or is it because everybody sees EB1, EB2 is current, so everybody floods the market and files, and suddenly now there's a retrogress, right? So there's all these things that you can't control and you don't know. But at least with the current administration and the policy, canceling a lot of family-based immigrations, trying to cancel, diversity visa and all sorts of things, moving the kind of visa category to fund the EB1 and EB2 categories.
Okay, and then someone is asking for general guidance to change from B2 to F1.
Okay.
Currently in the U.S. on a B2, along with wife and children, and then they plan to start studies.
Wow.
Just general,
Okay.
I guess, insight.
Insight. Your educational plan and your career plan and your resume and for your entire family has never been more important. So what do I mean by that? The officer won't get a chance to interview one-on-one. And so it's all the way up to this particular officer. And just know, these officers are very strict on B1, B2 change to F1 status these days, right? Everything is discretionary. So just because you have the basics doesn't mean they will approve it. And so you really have to make them like you. You really have to prove that you are here and what you're doing is going to make America more prosperous, make America stronger, make America safer, and you comply with the intent and you are a good individual. There's nothing wrong in your background. So you need to be like A+++. How do you do that? Well, demonstrate that in 5 pages, right? What did you do before coming to the U.S.? What was your profession, career? You're not doing this just so you get a status and your whole family can stay. You are doing this to really advance your personal career and your wealth that you're going to be able to contribute to the United States, right? If you're just changing status to go to language school with your whole family, that kind of looks like you're a refugee, right? You're just coming into the U.S. You don't want to be in your home country. You want to stay here. You might be working on the table. They have all these suspicions. Deal with those suspicions, deal with those prejudices, prepare your case, make a good argument that why you're going to the school and this school is going to lead you to a particular industry, a particular job. You guys have enough funding, way more than the poverty guideline. You'll be able to stay, live, and contribute to basically the U.S. economy. So you're doing things the right way. You're not just crossing illegally and providing lots of documents, bank statements, resumes and everything, and pictures. To show that you are who they want to approve.
And is premium processing available for all applicants or only for the main F1 applicant?
Oh, good question. That's a good question. I don't know. Yeah, I know they just did the premium processing for B2 change to F1. That was a couple years ago. But since then, I don't remember if that applies to other people as well. Yeah, I'll have to look that up.
Okay. And then going back to the main chat, we have a question about will my I-130 get denied if the petitioner was at any time on welfare but no longer is?
I would recommend you take a look at the public charge memo or our video on the public charge that we did. We spent a lot of time on doing it. My short answer is maybe. And the reason why is because now it's a factor test. What the petitioner did, the family members of the petitioner, everything becomes a factor in analyzing a particular case, whether or not you will be a public charge. So the most important factors, your education, your job history, your assets, the petitioner's work history, career, assets, health, those are things that they look at, basically thinking in the next 10 years, are you going to be able to hold down a job, make money, pay income tax, etc. That's what they want to see. So if in the past, there was one negative small incident, a couple months, okay, you file for bankruptcy here, you have a low credit score here, but, you turned yourself around. I mean, look, our president has filed bankruptcy how many times? And he became president, right? So you can make an argument that, it made you stronger and you are now more prosperous and you're able to contribute. Then good. But it's a factor test now, case by case basis. And so that's a very big thing that this administration is focusing on.
Okay, next question is, do you think that the ban to the 75 countries will be uplifted soon?
I do not. Yeah, I see this every single week. I predict it will stay there for the next 3 years. I predict it will expand potentially. Maybe even had more additional countries and variations added to it. And I definitely think once they figure out what the rules are for public charge, they will issue another memo, and USCIS will start clamping down. So that's the next thing, because 75 country ban is only for the consulate. It's definitely going to work itself into the U.S.
Okay, and let's see. My wife was an LPR when filing my I-130. Now she is a naturalized citizen. How do I update the case? I guess it depends if it's through USCIS or
Yeah.
if it was overseas, but basically you just notify them
Right.
in either way. So if it was USCIS, then you sent them, we usually do like a letter saying now they're a naturalized citizen, we attach the certificate of citizenship.
Right.
and we sent it to the place that it was filed, or if it's at the consulate, then we try to find the correct contact and then draft an email for them too.
I remember you worked on that one case for that doctor, where it was like EB2 and then EB3 and then EB2. Like
It happens often.
we switched it 2-3 times.
Yeah.
You were so minorly annoyed. These clients like, oh, this priority is faster. Please change it.
Yeah.
And then you change it, and then this priority change it again. Like, okay, we just changed it a while ago, and then now become a citizen. Now please change it again. You know, back and forth.
Yeah.
Yeah, it's a lot of work.
Yeah, that one was very complicated
Yeah.
because usually if you're a citizen, then it moves faster. But that one was employment based, and
Yeah.
in that case, that category was moving quicker. So it was just a unique one. But
Yeah.
Yeah.
Yeah. You constantly want to watch and decide and make a gamble which one's right or wrong. But usually, right, when you become a citizen, everything becomes faster, generally speaking. And then so you just immediately file an upgrade.
let's see for my wife. Okay, so this one is I'm a U.S. citizen. I filed I-130 for my wife in India in March 2025. When can I accept I-130 approval?
Sorry, I tuned out. I was just thinking about the doctor and you. That was a fun moment. Okay, say it again.
Okay, so U.S. citizen filed I-130 for petition for wife who's in India in March of 2025. So he's wondering how long the I-130 approval will take.
Oh, I don't know. You probably see more
Yeah.
of that than I do.
I mean, generally a year,
Mhm.
I would say, but
Yeah.
it kind of depends. Let's see, when filing. This one is related to bonds, so I'm not sure if we'll have the answers, but we can try. My husband got his bond granted for habeas corpus today, but DHS
Nice.
paused it. What
Nice.
happens now?
Nice. From what we have seen, right? Again, our office doesn't do the habeas corpus removal defense, but we are partnered with a lot of firms that do, and so I'm always hearing their stories. What we predict, well, not we, but what we have seen, right, is that there's a high chance that the court will drop the trial and the removal case will be terminated. That is the best news for anybody that's living in the United States in this circumstance right now. Why? Why is that good news? Because if it is terminated, then ICE has less of an incentive to go after you again. If you have a case, they could reopen it, but they don't want to reopen cases that got recently terminated because they don't want to close cases, right? So again, here's some of the facts. Immigration courts don't want to close cases. ICE wants to pick up as many people as they can, right? And so in your situation, if you've already got picked up, if you've already went through removal of defense, and if you won the case and you got bond, which is all things that they don't usually do, and they terminate the case, then essentially you are practically safe from all the crazy threats that are out there. And that's almost the next best thing compared to just getting your green card. Now, obviously, if you have a good viable argument, whether it's 42B or 48, whatever your case is, right? Maybe you don't want them to close the case and you want to fight it through and get the green card, right? So that I'm assuming you have a weak case and they might close it, right? And the reason I say that is because most habeas cases are filed when they have weak cases. But, you know, you might be a green card holder that got detained unlawfully and you filed the habeas, and that's a different story, right? So it's a huge win. I'm happy for you. See what happens. Keep us posted.
Okay, and then someone is asking, can I work in a seasonal job with my green card extension while pending I-751?
Yes, you can work at any job, seasonal, unseasonal.
Okay. How long do adjustment of status take from H-1B to EB3?
So the adjustment status portion of it is the same as everybody else, right? If it's super, super clean and fast, maybe 5-6 months. Typically, we recommend people wait a year, but that's the 45 stage. If you're asking about the I-140 stage, meaning after perm, after advertising, and then you file the I-140, and then you have to wait for the priority date, whether it's EB2 or EB3, that could take years, right, depending on which country you are. So if you're asking, I already filed the I-140, I already got my EB2 or EB3 approved, I already have my priority date. It's already current because of the March visa bulletin. I'm ready to file 45 now. Well, then maybe a year, right? Just make sure your employer signs the Schedule J.
Okay, I want to switch back, finish up. Are you done talking about the news?
Give me one more segment to
Uh-huh.
talk about the news, and then we could go to success story, right?
Okay, and we'll answer some questions in between.
Okay. So here's a question that was completely stunned the other day when a client asked me, what is it that custom wants? And I said my usual thing, which is they're government workers, they want to do a good job, they're police officers, right? And they said, but everything I see on the news, people getting detained, whether you're a visa holder, whether you have valid visas, whether you have a green card, even US citizens, it's just so scary. And I was forced to say this, and I said, I really hope that this is not the case. If it is, I will be extremely sad and be sad for this country as well. And I don't believe customs officers have any sort of quota or incentive to send people to ICE. We know ICE has quotas. We know ICE gets bonuses for everybody they detain. That's been well documented. That's been said publicly. That's in their policy. That's part of their bonus. That's part of their hiring. Is that right? Is that wrong? You know, California Highway Patrol also have quotas to give people tickets. Is that right or wrong? You know, that's a different story. But I don't believe custom officers have that yet. I don't believe they're incentivized to do that yet. I hope ICE is not pressuring customs to give us more, and customs is under any sort of influence to try to detain people, because the entire immigration system, so much of it relies on the good, discretionary, fair judgment of custom officers. Is leaving 3 months, 6 months, 9 months, a year, 3 years? Is leaving that amount of time as a green card holder constitute an abandonment? To them, they are making a very important judgment call that will affect this person, this company, and their entire lives. And to them, they are the first point of contact to take on this case and to pass it over, whether it's to ICE, to give it to NTA, or to give it to the district attorney for this trial. And so if customs officer willy-nilly make these arbitrary decisions because of prejudice, because of biases, that will be bad. But what's even worse than individual prejudice and biases is if there's a systematic pressure by ICE to meet a quota for customs officers to do this. I think this will be a very bad stain on the reputation of the United States, very much like what we saw with the United Kingdom passenger who had a valid travel visa and got detained for 6 weeks. And that's not the first we saw. We've seen plenty of situations like that. Custom is getting back to how strict they were prior to COVID. That is a fact. We've been saying that. We've been seeing that. They've been saying that for years, and they're finally now doing it. It's still complying with the law, but it's now getting close to potentially being overboard, leading to the suspicion whether or not they are under pressure by ICE to meet a certain quota. I still hope that that's not the case. I don't want it to be. I think that would be really ugly. But I just wish everybody be safe and do your best to prepare yourself. Do not take what you had experienced for the past 5 years for granted. Customs officer from 2020 to 2025, the standard definitely was more lenient. But if you need to zoom back out to think of this as the 9/11 moment, right? Customs officer became super strict after 9/11. So if you have a case, if you have something of concern, prepare well so you can explain appropriately. That is my encouragement. Wish you guys the best. Okay, so that's the news.
So we'll jump into a few more questions and then go to the success story.
All right.
Okay. So, can I attend my interview once priority date is current despite the visa pause?
Yes. If you're part of the 75 country pause, the consulate calls you in for an interview, definitely do it, ace it, win it. They can't give you the visa yet. It would just be sitting there on the desk. And once the visa pause is lifted, then they'll call you back in and issue it.
Yeah, we had a client recently who went to their interview in Nigeria and one that's going to Burma interview. So we are advising them to attend, and then pretty much after that, we're documenting it and sending an email to the embassy just so that they know that they did attend, everything went well, and hopefully once the ban is lifted, then they'll approve the visa.
Right.
Okay, let's see. What's the best way to file taxes for adjustment of status with no SS Social Security or ITIN? Should I file jointly and file a W-7?
That's beyond my wheelhouse. Sorry. Recommend talk to a CPA on what's the best way to apply. Now, I could talk about something a little bit scary that we just had a meeting about. I just met with 6 other attorneys that's focusing on ICE enforcement at work sites, I-9 audits specifically. And what we were talking about is these I-9 audits where ICE agents go to businesses, inspect your papers to see if you have everything so you have authorization to work. Before, that's a very transactional, very simple process. Scary for most people, but at the end of the day, it's just, do you have your paperwork? No, you get a fine. Rarely does it lead to a criminal charge unless there's a pattern of offense, right? So, what we're seeing is that a lot of these I-9 audits lead to raids these days. So I-9 audits are now becoming like a discovery process for the government. Oh, you have 700 people here. Oh, a lot of them are 1099. Oh, you don't have, all sorts of paperwork. Okay, cool. Wait for our paperwork. We'll send you a notice. And then suddenly a raid comes. Everybody gets arrested. Obviously, super scary. That's something we're talking and we're working with different attorneys to build out a solution for a lot of companies and businesses, right? Now, one of the questions that I asked in this meeting was, ICE is doing that with I-9s. What about interviews? What about adjustment interviews? Go to there, and they said, oh, how did you work? Oh, I worked under a table. In the past, that has never been a problem. Never has been a problem. Case still gets approved. It is not an inadmissibility to get your green card denied. However, will this lead to USCIS giving a tip to ICE, and now ICE goes for a raid at your employment? That becomes a different story. So, a lot of things to think about. I'm just sharing exactly what happened yesterday at this big AILA meeting for worksite enforcement, tangentially related to what you talked about. Yeah.
Okay, and then switching back to YouTube questions, how will a dismissed domestic charge impact naturalization process for a green card holder?
Good moral character analysis. You have to explain what happened wasn't depraved, a crime of moral turpitude, is not a stain on your character. Prove everything that you do that shows that you are a good model citizen. This N400 policy just changed last year as well. I believe around November, December, something like that. We did another video in depth about good moral character. You can definitely find it on our YouTube channel. So any case that's like that, you definitely want to explain and argue well. Nowadays we do a good moral character packet when we do N400. So we show all the things that you have a good moral character based on their memo.
Okay. Someone said, I have a green card by marriage, but now divorced. What precautions should I take leaving or entering the country?
The custom officer doesn't really care that much about whether marriage is real or not real and how you got your green card. To them, do you have a valid travel document to enter the country? That's the first step, right? Do you have a ticket to come in? You have your green card, so make sure it's not expired, make sure you extend it on time, make sure, if you want to be safe from questioning, because they're also concerned about, national security, get a global entry, apply for it, now you are safe, right? So do different things to kind of improve your credibility. Don't leave for too long, right? Those are things that they care about, not about your marriage, not about the divorce. That's your personal life. unless they see something that's flagged, but that's out of your control, right? So, yeah.
Yeah, we had a client who she was married and then she got divorced and she got an RFE. So she was thinking about traveling. So one of her concerns was, what if the case gets denied and then she's out of status? So in that situation, that was something that we did warn her to
Yeah.
be cautious about because she was like basically in limbo.
Right.
But-
So I'm assuming you already got your 10-year green card. But if you're in the process of it, I don't recommend traveling because if your case gets denied while overseas, it's really hard to get back. We've done it, right? We did motion to reopen and help clients come in, Margaret and I. In fact, for everybody watching, almost all the crazy entry cases that are very difficult, Margaret and I go down to Mexico, help people come in.
Okay, and then someone is asking, how long does it take to get SV1 visa?
It's really hard to get, really, really hard to get. Margaret and I, we did a case on it, and the client regretted it because it was so hard to get. They would rather just come in. But how long did it take? I mean, consulate processing typically 9 months, a year and a half. I remember that client took like 2.5 years plus, you know. To them, just so you know, when you do an SB1, you're getting a brand new green card. So just imagine that whole process, NVC, consulate, or 45, all the criminal records, all the health records. It's a lot of work for the consulate and for you. So it's not something to want to do. So if you left the US for anything more than a year, chances are it will get denied. It's a very low chance of success. If it's under a year, why even bother with this SB1? Just apply for the I-131A, right? You can get another travel permit and come back in. So SB1 is just terrible. And I talked with a lot of consular officers and they said, you know, I've never seen it approved. We've done few, but it's just so rare.
Okay, someone has a biometrics appointment next week, and then they have a removal proceedings, which isn't scheduled by the court yet, so they're wondering if it's safe to go to that biometrics.
That's so hard to say. I rarely see people get picked up at the biometrics. So, is it possible? Sure. Do people pay for attorneys to go with them to a biometrics? Yes. But it's just so rare that we see people getting picked up at biometrics. So, I mean, we want a case where the client didn't go to biometrics and didn't go through ICE, showing. So maybe, but I don't want to advise you for that. The client did it on their own. We were very angry that the client didn't show to the appointment, but they were just terrified and can't blame them if they're scared. But anyways, again, just want to say it's rare for ICE agents to pick people up at biometrics.
Following up on this customs question, so they are a green card holder. They just left for a vacation. They have everything is valid. But what kind of concerns could get raised at, on the immigration level? Leaving for vacation, coming back, what are consulate officers?
Yeah. So, customs officers, right? So if you travel less than 180 days and you generally stay in the U.S. and this is just a 1 or 2 or 3, small vacations out of the country, they don't treat this as an admission. Meaning, they treat it as you never left. So meaning they don't usually in-depth question you because it's more work for them. They don't have to, right? You could just walk in. They're also obviously supposed to check if you bring drugs, if you're smuggling stuff, so national security stuff. But generally speaking, they're not quote unquote admitting you because it was a short, innocent, temporary trip. So that's not to be worried. But if you have a pattern of that where you only stay in the U.S. for like a couple of days and you fly out for 170 days, you fly back for a couple of days, this pattern makes them feel like you might have abandoned it. Then it's a different story.
Okay. Trying to file for my green card, but my spouse or family won't sponsor. Will there be an issue if I find a friend to help?
We have definitely seen a lot of cases get approved through friend sponsors. So, but this is getting close to the tricky area, right? So you would definitely find the friend. This is what I recommend. Find the friend is willing, have them look through the 864 form, ChatGPT it, give them the summary of it, make sure they're good on it. Once they're good on it, then do a consultation with a third party, us, another attorney, doesn't matter, and explain the process to the two of you. And then, again, once they're good and clear on it, then start the process. I don't know how many cases we've started and done, and then at the very end, right before filing, the joint sponsor backs out, saying, oh, sorry, I'm not willing to sign anymore. And then the whole case is paused, and then they have to go find somebody else, right? So, make sure they're clear on everything they're signing up for.
Okay, I want to jump into our success story, and then we'll go to questions if we have time at the end. So what is the success story today about?
Today's success story is about the N600. It is something that is fairly rare, surprisingly, but it is something so important. The N600, similar to the N400, allows somebody just directly become a citizen. Now, N600 are for children. So N400 is if you're in the US, been here for 3 years, 5 years, you apply for citizenship as a green card holder, right? It's the next step up from a green card holder, you apply, become a citizen. But what if your parents are already citizen and the child is only a green card holder? Well, in that instance, the child could just apply for an N600 and get the case approved. So this case was a really special one because the mother applied for the N600 on her own, but realized it was going to get denied. There were so many things that's wrong with it. The mother already tried to apply for the passport, I think twice. Both times got denied. Applied for the N600, filled out the entire application wrong. And not just like one area that's wrong, like 20 errors, right? And some very big ones. The mother had physical presence issues. The mother had whether or not she was married to the biological father, which she wasn't. What else is there? There was like
Yeah, I think one of the questions was like on the form. It asked, "Is a child in physical and legal custody?"
Right.
And which is like you have to have it in order to qualify.
Right.
And then the mother said no.
Hurrah.
So that was like one thing. So it wasn't just these very like minor typographical mistakes.
Right.
It was these big things that would for sure lead to denial.
Right. And so I don't know how she figured out that her case is going to get denied, but she figured it out. She contacted our office, and then Rebecca was working on the case and sat down with this grandmother, essentially, and reviewed this whole thing. And we said, okay, you have two options. Withdraw the case and file a new one, or because the case didn't get a request for evidence yet, we could wait for the request for and then answer it, or just, I guess, respond to it accordingly. There's three options. Yeah. There's no right answer, right? We've been to ALA conferences. We know the different speakers. We know the different people who work on N600. We work on a lot of N600. There's no definitive right way. If you withdraw the case, it's in the record. It might look bad. If you wait for a request for evidence, you might never get one. It might just directly get denied. And the unique thing about N600 is if it gets denied, you can't file it again. You have to do a motion to reopen. And then it becomes an indefinite problem, right? It could be a 6-month or it could be a 6-year processing for N600. So if it's a 290B motion to reopen. So it's complicated, convoluted, and you just have to make your choice and stick with it. The decision we made was to preemptively file an update for this N600. We attached our G28. We explained every single error that happened on the prior application, essentially redoing it and explaining everything and getting the legal custody, right? Because again, the mother and the father weren't together anymore. It was born out of wedlock. And there wasn't official documents to show that she has like the full custody. So getting the father to get that document written out, notarized, authenticated, sent over. We explained all the discrepancies, her annulment with another marriage, the physical presence with the child. It was a very thorough and detailed process. Filed it, no request for evidence, just strict approval, no interview needed. Kid is going to the oath ceremony. We filed it in July of 2025. We just got the approval, I think, like last week, February 2026. The family is overjoyed. It was a complicated case, and mainly complicated because it was wrong, and we have to correct it, right? And that always makes things hard, right? Imagine you're cooking, and you messed up on the dish, and then now instead of just re-cooking the dish, you have to use whatever you messed up, the burnt things. That sounds like me this morning. I burned my bacon. I had to just pick out the burnt bacon and then use the rest to cook, right? But yeah, it's hard to fix something that is already done, wrong. But it's not impossible. And I'm glad we made that right judgment call. And I guess we never know if there would there be a request for evidence. We didn't know if we withdrew it and refiled it. But what's guaranteed is if we did withdraw and file a new one, it would take a lot longer. Whereas this just took 6 months, So honestly, I don't know. I don't know if we would do it again for the next case. I guess it depends on every single situation. This was definitely a crazy complicated one. And I still don't know if we made the right choice, although the end result was definitely right. But yeah, I mean, what do you think about the case?
Yeah, I mean, I was really impressed with the amount of work. Like, it wasn't just a simple, let me correct the form and resend it back. I looked at the brief that Rebecca prepared, and she really explained every single question, why it was wrong, and gave the right answer in a very neat way that was easy to follow. I think we gave about 15 to 20 exhibits. So like you mentioned, it was like not only saying why it was wrong, but showing supporting evidence.
Yeah.
They had an opinion letter by a Hong Kong attorney. And a lot of these times, like, we don't know what's going to work. Sometimes we kind of go, we go above and beyond, I would say, for sure. But it's really rewarding when we get the end result, which in this case, it was a single mother. Her child was 17. She was under a lot of stress going to college and preparing for that. So I would say we did make the right call.
Yeah. The outcome was good. And the thing is, a lot of people don't realize how important N600 is. A lot of people try to do consular birth abroad. And they're just like, okay, I'm a U.S. citizen. My child, they should be a U.S. citizen. They try to do consular birth abroad. But because they didn't live in the United States for that long, they're expats, kind of like me, live overseas almost my whole life before coming to the U.S. If they don't live in the U.S. enough, they cannot pass on their citizenship to their kids. And they just give up. And I'm like, don't give up. You know, do the normal immigration path, get them the green card, come to the U.S., and then apply for the N600. And then the kid gets this in. It's just one extra step, you know, 2 extra steps. But you could still get the citizenship pretty fast. You know, so I encourage people to do that. So most people don't know about the N600 route. They just think it's so long and so tedious, but it's definitely workable. And yeah, I mean, I would say the most complicated N600 cases are when it's out of wedlock, especially if it's the father, because then how do you prove this is really your kid? I mean, other than DNA, but you also want to prove, you know, that you cared for the kid and you have the physical custody of the kid, and so that's really important. And they have to be able to get a green card and come to the U.S. and be in the U.S. and then you file the N600. Now, USCIS does clamp down on N600s because they think there is a lot of fraud, just like following to join. It's things that, you know, it's not the normal route. It's not like the I-130, I-140, and then all these background checks and then interview. It's really just application documents. And it's like a lot of it's secondary documents, like pictures and stuff. You file it, you know, and you get, suddenly you get a naturalization certificate and you become a citizen. That's pretty crazy. But, you know, this happens a lot. And I'm glad we were able to save this family. Yeah. All right. Any other questions?
Let's take some few more questions before we
Okay,
end.
so this one's related to N600. So they initially applied for I-485 for their child in 2023. Then they were told that they have to apply for the N600 in 2024, and they're still waiting. So she's saying almost 3 years.
Too long. Way too long. Maybe look into mandamus action. Right, or if you know which field center, do an info pass and try to just really press to speak to a supervisor. My guess is they lost the case. You know, past 3 years has been pretty busy, and N600 is very rare. Officers move around. Your file just got lost in the system. So go there. Be a good Karen to help the officer find the case to approve it.
Okay, this question I think a lot of people are scared about right now. So is everyone who overstayed getting arrested at USCIS interview?
I don't know. I don't know. I would not say it is everyone because I'm on a lot of lawyer threads and we share news, and every time something bad happens, you immediately get 5, 7, 8, you know, comments saying, my case just did it and nothing happened. Whether they're gloating, they're not gloating, you know, don't read too much into it. I believe them because they're putting their reputation on the line. If every single person who overstayed their I-94, whether on a visa waiver or a tourist visa, is getting detained, I think we will see a lot more news. So the question is not, is everyone getting detained? I think the bigger question is, what is the percentage? Is it 50%? Is it 25%? Is it 10%? I think that is the harder thing. And also, just so you know, if you are on visa waiver overstay compared to B1, B2, that's also different. So if you're part of the 9th district, which California, right? If you are if you're a ESTA overstay, you have much more protection. You won't, hopefully, you won't get detained and without bail. Whereas if you're, in Texas, visa overstay, ESTA overstay, you could be held without bail. So there's these little minor differences, but if you're just asking a blank question, is everybody, I think the answer is pretty clearly no. You're still safe to file, but definitely make your case as good as possible.
Yeah, I think certain locations are stricter because when
Yeah.
we went to ALA conference, specifically the attorneys from San Diego,
Yeah.
those are the ones I noticed were sharing more incidents of clients actually being detained.
Right. And that only happened last year, October, November, during that time, and then it sort of stopped, both at San Diego and the rest, right? And so it's a scary time for sure.
Okay, someone is asking, can I petition my adopted sister who is adopted at 19 years old?
Can you petition your adopted sister? I don't know. I don't think I've done a case like that. I would check on it, So yeah, I would definitely look up, can you petition sibling as a U.S. citizen, but they're adopted. Yeah, we've never done that.
How long to get EAD through EB3?
If your EB3 petition was already approved, priority is current, you file for adjustment of status, typically you get it within 4 weeks. You get it within 4 months. But hopefully your H-1B is still valid, so you could still have your EAD card, right? So you don't need that EAD card. So it's quite rare where we see that. Now, if your H-1B is terminated and you're filing for adjustment, then that's a different story. But typically, after you file the 45, 765, within 4 months, you typically see a EAD card.
Okay, and this one's, I think, more so in regards to removal, which we don't necessarily specialize in, but the question is, what does terminated proceedings mean after a master hearing?
It means they're not going to deport you. It means the case is closed. And the U.S. judicial system, plus ICE, plus removal, they don't like closing and they don't like reopening. And so effectively, that almost means if your case was closed, you're a free man or a woman. And that is the next best thing to having a green card in this immigration world.
Okay, and that is our time. Thank you everyone for watching.
Thank you guys. See you guys next week. Take care. Bye.
Okay, we will end the live and end the live and